Hi, my name is Nicole Eggenberger, and today I'll be talking about sexual harassment in the workplace. Some of the topics that I will be addressing in this presentation include how sexual harassment in a workplace is defined, the two different types of sexual harassment, Title VII of the Civil Rights Act of 1964, Equal Employment Opportunities Commission, New Mexico laws, the history and evolution, and the steps to take if you are being sexually harassed. To start off with, it is important to understand what sexual harassment is. Sexual harassment in a workplace is when someone has had any unwanted sexual advances, sexual favors, or other verbal or physical conduct of a sexual nature at work. Some people may not even realize they are being sexually harassed, and although we mainly hear many cases about females being sexually harassed, men can be victims too. Knowing what sexual harassment is will help someone tell if they have been harassed and what they need to do. It is our right as Americans to report any unwanted sexual advances. Furthermore, we will discuss the two different types of sexual harassment, which include quid pro quo and hostile environment. First off, let's talk about quid pro quo sexual harassment. This occurs when an employee gets on the promotion track, or even when they get to keep their job based on if the employee submitted to or rejected sexual advances or other types of inappropriate sexual comments. An example of this would be if a manager at a firm says to someone, "That skirt is really sexy on you," or even as simple as, "Why don't you come over tomorrow to my house and we can have dinner and talk about your promotion." This is inappropriate and should be reported, in which we will talk about later in steps of what to do if you are being sexually harassed at work. Secondly, the hostile environment happens when a coworker or a supervisor in the workplace makes sexual advances or comments to an employee that, while not affecting promotions or the future of the employee's job, makes the working environment of the employee offensive and hostile. Examples of hostile harassment include personal questions of a sexual nature, vulgarities, or other offensive language, physical conduct that is sexual or degrading to any reasonable person, and any sexually explicit or offensive pictures or literature that is in plain sight of other employees. If there is anything remotely similar to what has been discussed about the different types of sexual harassment in a workplace, it should be reported immediately to put them to a stop. Avoiding reporting situations like these can result in future sexual harassment on you and possibly on other employees as well. As we continue, it is important to know our rights and the laws that cover sexual harassment. The laws of sexual harassment include Title VII of the Civil Rights Act of 1964 and the Equal Employment Opportunities Commission, which both help protect us in regards to sexual harassment in a workplace. Title VII is a federal law that prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. Because of this law, we are protected and have the right to report any unwanted sexual conflicts. Not only does Title VII protect us in the workplace, but it can also protect us in different colleges and labor organizations. With the Equal Employment Opportunity Commission, it is defined as unwelcome sexual advances or conduct of a sexual nature which unreasonably interferes with the performance of a person's job or creates an intimidating, hostile, or offensive work environment. How does this process work? Equal Opportunity Employment Commission first receives the complaint and then tells the employer what has happened and will proceed to do an investigation on the situation. Equal Opportunity Employment Commission may attempt to settle your complaint or refer you and your employer to a mediator, which may file a lawsuit in federal court or may choose to simply dismiss the charge. If charges are dismissed, or if Equal Opportunity Employment Commission is unable to reach an agreement to settle the complaint, it will issue a notice to you advising you of your right to sue in court. This is called Right to Sue Letter. Title VII and Equal Opportunity Employment Commission are very similar in which they work towards protecting the victims of sexual harassment at work and allows us to be not taken advantage of. These laws here to protect us, as it is our right to be treated with the utmost of respect. Laws in New Mexico include New Mexico Human Rights Act, which is defined as illegal for an employer to discriminate on the basis of sex, race, color, national origin, ancestry, religion, physical and mental handicap, special affiliation, sexual orientation, gender identity, or serious medical condition. The New Mexico Human Rights Act is very similar to that of the Title VII. In New Mexico, harassment is defined as unwelcome comments or actions based on the target's protected trait that create a hostile or offensive working environment, or that the target must endure in order to get or create a job. Whomever makes a claim on sexual harassment in the workplace is protected from retaliation in New Mexico. The history and evolution of sexual harassment really started to shine through in the 1970s. During this time, lawyers that would represent women found that there was an overwhelming amount of sexual harassment cases. Due to the feminist movement and women starting to get jobs, many women spoke about being harassed at work. The legal system started to change as they recognized women's rights in being able to work free of unwanted sexual advances. Women had to prove to the courts by protesting. By the year 1980, Equal Employment Opportunity Commission stated that sexual harassment is a form of sex discrimination prohibited by Title VII. In 1986, the Supreme Court ruled that the sexual harassment is a form of sex discrimination prohibited by Title VII. The practice of sexual harassment has been ongoing over the years since 1970, when courts were first starting to recognize harassment as discrimination, which led to it being a part of Title VII. As years go by, we become more aware of sexual harassment and more cases pop up. Because more cases are becoming public, the rules, policies, and laws have become more strict. It is still to this day a problem in the workforce in which many cases may not have even been reported. As we continue, I will discuss the two main cases in which led to sexual harassment being considered a sex discrimination of Title VII. These two cases include Williams v. Saxby and Barnes v. Train. The Williams v. Saxby case happened in 1976, where Diane Williams was fired from her job as a public information specialist at the U.S. Justice Department after refusing the sexual advances to her boss. She sued in a Washington federal court and won. Getting fired by refusing sexual advances from her boss is a form of sexual harassment. 2 years later, in 1977, Paulette Barnes was a payroll clerk at the U.S. Environmental Protection Agency. After going to work, her male supervisor started demanding sex, suggesting that she would benefit career-wise if she complied. She didn't and was eventually fired. Barnes sued, lost, and ultimately won on appeal. Her case was a form of sexual harassment in which her supervisor demanded sex to help benefit her career. But since she denied it, she was fired. Being fired due to not having sex with her supervisor is sex discrimination, which violates Title VII. These two are the most known cases that led to sexual harassment becoming a part of sex discrimination in Title VII. There are other cases of sexual harassment, but these two specifically helped the Supreme Court recognize sexual harassment as a civil rights violation in 1986. Now that we know the basics of sexual harassment and its laws, it is also important to understand what things we can do to prevent this type of behavior. If anyone is involved in being harassed, try to stop whomever is harassing you immediately. Whether this be a letter or in person, make sure you make a copy. Some harassers may not recognize they are harassing you, so it is important to tell them to stop. After that, if the harassment still continues, go to someone higher up and try and get a solution to the problem. One of the most important things to remember to do is make sure to write everything down. By writing things down, you have evidence to help prove wrongdoing and to help yourself if it would pursue to court. The more evidence you have for proof in court will only build on your case and help you in the long run. After all those steps are taken, it is wise to find a good attorney to look over everything to evaluate your claim. Attorneys can be very helpful in which they can help you get through this type of situation and win your case to be at ease of mind. In conclusion, it is important to understand sexual harassment in the workforce and the laws that are put into place to protect the people of the United States. Thank you for watching my presentation. Goodbye.